end, and there will be a live Q&A at the end as well.
And I think we're also, within reason, happy to take questions on anything which is exercising you at the moment, even if it's not one of those topics.
Provided it's employment related.
Provided it's employment
or data protection, as you're in the room.
Oh, thanks for that.
So, what are we going to be looking at today? So we're going to be talking about, I'm going to be talking about COVID-19 vaccines and the current situation, but you may be relieved to know that's the only topic we're going to be covering that's COVID related. Matthew's going to be talking about where we are in terms of holiday pay. There's some cases that are kind of going to the higher appellate courts, which are noteworthy. And you're also going to be looking at transgender rights as well, because that's something that's becoming more prominent and talked about. And there's some interesting cases there as well. And finally, I'm going to be talking about menopause at work. I think during 2021, it's fair to say that a spotlight really has shone in terms of women and the symptoms they suffer when they go through the menopause and coping with work at the same time. And there's been some developments in this area, which I would like to take you through. And as we've mentioned as well, there will be time at the end for some questions and answers. So moving straight into the lovely topic of COVID-19 and vaccinations. So what's the current situation? Well, just as a recap, which I'm sure you all know, in terms of eligibility now, it's anybody aged 12 and over that are eligible for vaccines. That's for the first and second dose, and the booster is available for 16s and over. The take-up, I had a quick look at the government dashboard as of the 26th of January, so that was the end of last week. 52 million of us who are eligible have had our first dose, which is 91%. Second doses is about 84%, and boosters, there's 37 million that have been administered so far, which I guess is probably about 55% of the population. I think we also know that variation has tended to differ across the country in terms of take-up. So we find that, for example, the Southwest has got an 86% take-up, whereas London has only reached 69%. And there's also disparities we found across different ethnic groups and also between poorer and wealthier areas. I've put effectiveness up on there. I think it's worth making the point that, and does become relevant when we look at mandatory vaccines, is that in terms of effectiveness, we know that the vaccines are very effective in helping to prevent serious illness and hospitalizations. However, particularly with, I think, the Omicron vaccine now, Omicron variant now, the effectiveness of vaccines in preventing transmission is perhaps lower than we originally hoped for. And as I say, that is relevant. So mandatory vaccines in the health and social care sector. So from November last year, workers in Care Quality Commission regulated care homes, those employees who worked in those care homes must have been vaccinated unless they were exempt from November last year. And these regulations extended mandatory vaccination to workers in health and social care sector who have face-to-face contact with service users. So we're talking about the NHS. From the 1st of April. So in order to meet the deadline, affected employees needed to have their first dose of vaccine by today, the 3rd of February. And the NHS guidance currently advises that notice of termination can be given to employees who remain unvaccinated after the 3rd of Feb. However, there's been a bit of a hint, a suggestion, a very strong suggestion that there's a U-turn coming from the government. In light of what they say are dramatic changes, and I think they're talking about greater population protection now, and also the reduced severity of Omicron compared to the previous variants. Since the original decision, the government's now of the view that potentially statutory mandatory vaccination requirement won't be proportionate, given the impact on existing NHS staffing levels. So on Monday this week, it was announced that the government intends to revoke both sets of regulations, so that's in relation to the NHS and the care homes, with regards to mandatory vaccination. But it's going through, I think, a 2-week parliamentary kind of consultation and approval. But it very strongly looks like that's the road that they're going down. And also, it was confirmed that if that does happen, that those that did work in the care sector and who are then dismissed may choose to work there again. Not quite sure how that will work in practice, but yes, so basically you can get your job back, but without continuity of employment. That point was made. So yes, we're expecting the the rubber stamp on that very shortly, and I think that development is actually very relevant when we look at our own workplaces and mandatory vaccines. So what are we, when we're looking at unvaccinated employees, I think, I've had many conversations with various clients over the past year in terms of vaccination and concerns about whether all employees are vaccinated, and other employees feeling uncomfortable if they're working next to somebody who's unvaccinated. And there is, clearly a desire in an absolute ideal world that all your employees would be vaccinated, because there's a sense with, scientific backing that, safe goes to a safer workplace. And of course, our advice very much last year was one of the key things you can do is, of course, promote vaccination within the workplace. Provide perhaps fact sheets to employees, be informative, and also encourage them to have the vaccine by saying, right, the time for you to go and attend your vaccine appointment is paid. So kind of putting things in place to enable and potentially encourage vaccination. But what about the key question now of employers requiring employees to be vaccinated? Well, essentially our advice is the same as the previous webinars. When we talked about this last year, ICAS still advises employers to encourage and support their staff with vaccines. The Employment Human Rights Commission last year warned that blanket mandatory vaccination policies were, if applied inflexibly, were likely to be unlawful due to vaccination not being suitable for everybody, and of course discrimination risks. So in the absence of a vaccine becoming a legal requirement in the sector that you work in, then really an employer can't actually force an employee to get vaccinated. But of course, there may be measures they would want to take, for example, disciplinary action or potentially even up to dismissal. So what are the key considerations? Well, let's just have a quick recap really of them. I'm not going to go into detail on all of them because I'm sure you'll be familiar with them anyway. But obviously, vaccinations aren't suitable for everybody. And when I say that, I'm talking about employees who may have particular health conditions where they've been advised not to have a vaccine. When we're looking at dismissal or potentially disciplinary action for failing to have the vaccine, some employees may seek to rely on the fact that, well, this is a reasonable management instruction that we're giving you to have the vaccine. But I think that is risky. I think the tribunals are most probably unlikely to consider a vaccination requirement reasonable. I think particularly given that, where there are mandatory vaccines now, it's like they're going to be U-turned in the healthcare sector. And I suspect the tribunal would really sympathise with the employee. Of course, we do need to, with disciplinary action, you'd have to be careful of potential repudiatory breaches of contracts leading to constructive unfair dismissal claims. And of course, with dismissal, you have the potential unfair dismissal claims. Any other potentially fair reasons? Well, there's that lovely catch-all of some other substantial reason. But again, the obligation on the employers to show that they acted reasonably in treating that as a decision to dismiss. I think the same points really apply when looking at conduct. And of course, there is that other potentially fair reason of the statutory restriction. But of course, that only applies if your sector is one where there is a statutory mandatory requirement. And of course, that only applies to kind of one main sector, and that looks like that's being removed. So fairness, I think, is an issue, and also so is discrimination, particularly an indirect discrimination risk if you have a mandatory vaccine policy. The protected characteristics in particular would be potentially disability, maybe even still pregnancy, because of course the guidance in terms of having the vaccine, don't have the vaccine has changed. So some pregnant women may be more hesitant than others, the non-pregnant women, to have the vaccine. And of course there's race. We know that there's a lower take up in certain areas where there's a high proportion of ethnic minorities due to their hesitancy, and also potentially religion and belief protected characteristic as well. So where there is indirect discrimination, where that group feels they're being treated to a disadvantage, then of course an employer would look to justify the measure or the policy that they're taking. And I think, it has to be a proportionate means of achieving a legitimate aim. Well, the legitimate aim, I think, as we've talked about before, you look at the health and safety within the workplace. I think that would be a legitimate aim, but I think where the issue comes is proportionality. That's likely to be the biggest hurdle because there other ways around it, of course, looking and complying with COVID secure guidelines, regular testing, home working, potentially redeployment. They're likely to be more effective and less discriminatory measures that can be taken. And also, especially now, I think imposing a mandatory vaccination, I think you run the risk of reputational damage potentially as well. And that may have detrimental impact on your business. And there are also data protection implications to consider if you require employees to provide information on their vaccination status. I'm not going to say anything more than that because I'm not the data protection expert, but if you have a particular question, then here we go on that. But it's something that we always do mention, that's something to keep in mind.
Can I just mention, just to get very quickly off the subject of data protection, one other thing which was occurring to me as you were speaking was one of the problems we've got is changing attitudes here.
Yeah.
And we can look at the state of attitudes about the vaccine, the virus, etc. now, but particularly with delays in tribunals, we've really got to be thinking, what does this look like in 2 years' time? Because that's when the tribunal is going to be taking their decisions over all of this.
Yeah.
And again, the landscape could look very, very different. So I think let's just bear in mind that even if we believe we've got good justification now, we could be in a very different place by the time the tribunal's looking at this. And I think we just need to bear that in mind.
Yeah, that's a really good point, and I completely agree with it. So as I put on there, I think in my view, certainly, I think we need to be looking at other measures that can be taken to protect the workforce, and it goes back to that promoting vaccination within the workplace as well. So other measures could include, requiring or promoting regular testing, and we know that lateral flow tests at the moment are still free and now accessible again. Having regular health and safety reviews of your workplace. If there's particular concerns, you may look to reintroduce or maintain social distancing, face masks, and also perhaps, home working or hybrid working to minimise the numbers of employees in the workplace. I've put incentivizing vaccinations on there because this has come up for me. And I think there's two ways. One is where employers potentially withhold sick pay for those employees who haven't been vaccinated and then get pinged or told to isolate. Because they've been in contact with somebody who's tested positive. Now, obviously, for those of us that may be vaccinated, we don't have that requirement now. But if you're unvaccinated, my understanding is that there is still a requirement to self-isolate. Now, these employees are still entitled to SSP, but of course, there may be enhanced company sick pay they would ordinarily be entitled to if they're off sick. And some companies are withholding that for unvaccinated employees, and Morrison's was one that was in the press.
Yeah, there were some others. I won't mention them just in case I got them wrong, and I don't want to be sick.
Morrison's was definitely one, so we'll stick with that one. But the other incentivization is that I've heard of employers actually offering like a small bonus or vouchers for staff to go and get the vaccine. Potentially controversial, costly, depending obviously the size of your organisation and number of employees. And I think, whilst I would have less concerns over that than, say, disciplining or dismissing an employee, because this is more kind of a positive thing as opposed to a negative action, I think the indirect discrimination risks still apply, because those that, for the reason of a protected characteristic, decide that they're not going to have the vaccine, they would consider them to be treated at a disadvantage, and then we would need to look to be able to justify the measures that we're taking.
Yeah, I think it's very popular in companies, because that's something which is being offered in the States by many employers, and indeed many states are giving that kind of incentives to people to be vaccinated as well. So we may see that in the UK from that perspective.
Yeah. That was all I was going to say about vaccinations. That's a bit of a summary as to kind of where we are, but I think the overall message is that we're not, I think actually, as you said, I think the move is kind of going away from mandatory vaccinations rather than towards.
I think that's certainly the trend we're picking up, and certainly I think, as you said, as we appear to be getting some kind of herd immunity in place, that will also reduce the significance perhaps of vaccinations. But as always, it's a watching brief.
Yes, it is. So, holiday pay?
And that's probably the last time I'm going to mention COVID, isn't it? Today.
Hope so. Well, it depends on the questions.
Well, it does depend on the questions. And I'd like to think that we've gone from COVID to holidays, which is something I think we're all hoping to have a few more of this year. But just when you thought it was safe to go back into the water, I'm not going to be talking about the luxuries of an all-inclusive trip to Greece or the Bahamas. I'm going to be talking about the working time regulations and holiday pay and the continuing saga that we have with regards to calculating holiday. Thank you. I can't work with my left hand. And what I want to do is look at a couple of cases. Now, both of these cases were actually in the courts last year, and both of them we perhaps didn't necessarily at the time look at the significance of them in the way in which we ordinarily would have done had we not had things like, I won't mention the word, I'll say furlough instead, and lockdowns to think about rather than other things. But they're both quite significant, and they're both going to the higher courts this year. So I thought I'd just touch upon them so that we can start to get ourselves back into the vibe of normal employment law matters. So the first one's the case of the Harper Trust and Brazell. And the facts of this are pretty straightforward, that Harper Trust runs a school. Ms. Brazell is a music teacher, still employed by the school, and if you look at the Court of Appeals judgment, they go out their way to actually, no, it was the submissions in the Supreme Court. They actually go out of their way to make it clear that they still enjoy a good working relationship, in spite of the fact that they're in litigation. So Brazell is a music teacher. She does a number of classes on a variable basis, normally lasting 30 minutes each, and then she's got some other duties around that. So her pay varies on a week-by-week basis. And also there are times, particularly school holidays, there are times when she has no work to do at all. So this will be a situation familiar to many of you, which is, well, how on earth do we calculate a holiday for someone who has pay which varies on a week-by-week basis, and also has some weeks where they're not being paid at all because they're not working. And they did the very pragmatic thing, is the thing which ACAS suggested, which is to say, well, let's effectively pay a rolled-up allowance of 12.07% of an hour's pay for each hour worked, and that's holiday. And they would give her an additional payment 3 times a year at the end of term. So that all sounds fine and sensible. But then the law got in the way. And what we ran up against was the fact that rolled up holiday pay, many of you will know, has become something which has fallen out of favour. It's not unlawful to pay it in many situations, but it's certainly fallen out of favour with the courts. But actually, if you look at the working time regulations, where you have an employee who has variable pay, then what you've got to do is work out what a week's pay is, and you work out a week's pay by calculating it, by calculating the average. It used to be over a 12-week reference period, now gone up to a 52-week reference period. And what the working time regulations also say is that you exclude from that any weeks during which there is no payment at all to the employee. Effectively, you take another week into account. Now, the issue is that this benefits employees who have weeks where they do not earn any pay. If you're a full-time worker, as I've said in the slide, if you're a full-time worker, then it's fine. If you work each week, then it's easy to calculate. Every week is taken into account. If you're a part-time worker who, say, works 3 days each week, then again, easy to calculate. You look at what pay's been earned in that week, you go back to 52 weeks, you get the average. What happens where you have a part-time worker, as with Ms. Brazel, who is, has weeks where she just doesn't earn, and a significant number of weeks where she doesn't earn. In this case, it was, I think she earned 37 weeks out of 52 each year. And one of the things which the judgment does is look at some more extreme versions of that. What happens if you've got someone who only works 4 weeks per year, etc. And the issue is the extent to which they are disproportionately benefited by the holiday pay calculation. Because rather than being able to take into account the actual pay they've earned over a 52-week period, you've got to instead assume they have worked 52 weeks in that year. And that, of course, bumps up their pay, or pumps up their average pay, and means that the amount of pay they receive for a week's worth of holiday is disproportionately high compared to other part-timers and to full-timers. So this was the issue which the Court of Appeal looked at, and the Court of Appeal said, yeah, you're right, it does have that effect, but that's what the working time regulations say. So that's what we're gonna have to do. They heard various arguments about the extent to which one can write, or the extent to which the courts can rewrite aspects of the working time regulations to deal with some aspects which might fall foul, in particular, of what we used to know as European Union law. I'm not sure what we call it now, but still there somewhere. But to be able to rewrite the regulations to cope with that. But they said no, they didn't need to do that. This was just an unfortunate side effect of a particular class of employees who would benefit. So that's what the Supreme Court is now looking at. How do we calculate holiday pay for those with a variable income who do not earn each week? Do we have to take into account weeks in which there are no earnings, or do we not? And that's the first thing I think we're going to see from the Supreme Court this year. So it's really about whether we're going to see the courts be pragmatic, or they're going to bake in to the law an unfairness. So watch this space, and we may be having to look at how we calculate different types of paid leave in the future. The next case is also really about baking in an unfairness, I suppose. And it's part of a saga, and it's a saga in three ways. We all know that holiday pay under the working time regulations has now been a saga for 10 years plus. It's a saga for Mr. Smith, who has been in litigation with Pimlico plumbers for about that length of time. And you may be aware that I think about 3 years ago now, Mr. Smith hit the headlines because he was able to establish that he was a worker for Pimlico plumbers rather than being self-employed. And one aspect of that case was the extent to which he was entitled to paid leave as a worker. As I said, it's a saga for Mr. Smith because his case about paid leave is still taking place and is going to the Court of Appeal this year. So what's the situation? Well, I put on there a case called King and Sash Windows, and this case goes back about 4 years now. It went to the European Court of Justice. Now, Mr. King was again in the same position of Mr. Smith in that he was told that he was self-employed rather than being a worker or being an employee. Because he was self-employed, he was not entitled to any paid leave. Now, crucially with Mr. King, the court accepted that the fact that his leave was not paid meant that he was discouraged from taking it. So he didn't take leave. I don't know if that meant he worked 52 weeks per year with no break or what, but he was discouraged from taking his right to pay leave. You'll also remember that the working time directive and indeed the working time regulations are effectively a health and safety measure, and paid leave is seen in that context, i.e. it's time away from the desk or the machinery or the sink or the sash windows, whatever else you're doing, to recharge your batteries. Effectively, I'm not sure that's a legal phrase, but let's stick with recharging of the batteries. And therefore, it was a fundamental right for Mr. King. Now, Mr. Smith, on the face of it, looks in a very similar position in that he was told he was self-employed, he accepted that for many years, and he didn't take paid leave. And by the time he had his claims is for about £74,000 worth of accrued holiday pay. However, the significant difference between Mr. King and Mr. Smith is that Mr. Smith did take time off. It was just unpaid time off. So he wasn't dissuaded or deterred from taking time off work in the way that Mr. King was. Mr. King couldn't afford it. Mr. Smith could. And again, one of the features in the Pimlico Plumbers case was just how well paid the plumbers were. So Mr. Smith could afford to have a few weeks off each year, which he took. So in Mr. King's case, the European Court of Justice said absolute fundamental right to take time off. You were deterred from taking it. Therefore, you have X years worth of accrued holiday to take, and on termination of your employment, that can be paid out. In Mr. Smith's case, he also sought to take these many years worth of accrued holiday, but he sought to claim the pay rather than the holiday itself. And the Employment Appeal Tribunal looked at that and said, well, that's not quite a fundamental right in the same way as Mr. King's case is. Mr. King's fundamental right, go off and recharge your batteries away from your sash windows. Mr. Smith, you were able to go and recharge your batteries. It's just you weren't paid for it, and you've got a claim for pay. Now, one of the things us nasty lawyers have always done when we look at claims for accrued holiday is to look at whether someone is out of time or in time. And what King said, and what we all thought for a long time is, well, okay, if it's a fundamental right, it continues to accrue, then it can just leap from 1 year to the next. And that gets an employee over those hurdles of having to establish any kind of additional right. If it's about pay, however, those limitation period, and in particular that 3-month limitation period, really matters. And effectively, for an employee to be able to, or a worker to be able to make that claim, they had to be able to establish that there wasn't a 3-month break between the leave they were claiming. Mr. Smith couldn't establish that, and indeed very few employees could. So Employment Appeal Tribunal said, yes, we know what King says. Mr. Smith, you're not in the same position. It's not so fundamental. So we are not we're not going to allow your claim to go forward because you can't establish that leave should accrue from year to year to year, because it is just in respect of pay that you're claiming, not in respect of the year itself. So this is the point that's going off to the Court of Appeal, and it's an important point. I think it's really important because we have a lot of claims, and we see a lot of claims for things like, well, do we have to take into account this element of overtime? Do we have to take into account this particular allowance? Certainly, over the past few years, you all know that we've been accepting increasingly that variable elements of pay, voluntary elements of pay, come into the calculation. But we've always had that ability to be able to defend those claims by finding a 3-month break. Now, if the Employment Appeal Tribunal judgment is reversed by the Court of Appeal, then arguably I think it opens up many accrued holiday pay claims in a way which wasn't so far. So watch this space, because we could find that some floodgates opening. So I know I disappointed you at the beginning, said I'd talk about holidays, and then I've just ended it by talking about how much it's going to potentially cost us all. So we'll look at the Court of Appeal judgment with interest. The next thing I want to talk about is transgender rights. Now, this does go back a bit to COVID, because actually what we're talking about is religion or belief. And transgender rights is starting to be at the forefront of the law relating to religion or belief discrimination. And I think it will have effect on some of the cases we might see coming through in a few years related to COVID about genuine belief that vaccination is bad, for example. So just bear that in mind, that there is this track back, but it's a very, very and increasingly important issue in its own way. So let's just look at transgender rights. And what we know is that the rights of transgender people are becoming increasingly visible. We also know that transgender people as a group are vulnerable to discrimination. And actually, these are statistics quoted in the case I'm going to look at in a minute. They're pretty shocking in some way. So almost 50% of transgender respondents in one survey by the TUC had experienced bullying and harassment at work. 30% had had their transgender status disclosed against their will, which is a shockingly high figure, I think, particularly given that there are legal restrictions on disclosure of transgender status. 1 in 3 employers, and this is a 2018 survey, I think, so it's a couple of years old, well, 4 years old now, but still recent. 1 in 3 employers admitted they were less likely to hire a transgender person, and 43%, so nearly 50% of employers were unsure as to whether or not they would. So there's a lot of discrimination about for transgender people, and that's something I think which the tribunals are very, very conscious of. At the same time, there's actually some really quite difficult issues to get through here. I just thought I'd put some pictures up for a change. We have J.K. Rowling, we have Professor Catherine Stock from Kent University, and we have Rosa Duffield, who's the MP for Canterbury, on one side. Now, all of these 3 individuals have been criticised for their stance on transgender rights. I'm not taking a view today as to whether or not the criticism is right or their stance is right, but they have a stance. They still approach this from a liberal perspective and they approach it from a feminist perspective, but what they have said has had significant effects on them. J.K. Rowling, I think she's come off Twitter now, but certainly she was highly criticised on Twitter. Professor Catherine Stock has just resigned from her position as professor because of it, and Rosie Duffield is on the verge of resigning as an MP again because of the hatred she's received, and because she says that the Parliamentary Labour Party has not supported her. So where does criticism come from? Well, it comes from the fact that they are perceived. Sorry, let me go back a bit.
Sorry, got eager.
It is, but unhappy. They are perceived as being TERFs, which are trans exclusionary radical feminists, and they're accused of being TERFs in particular by Stonewall, which many of you know is always was a very highly respected LGBTQ plus advocacy group. And the criticism comes because effectively, one way or another, they've expressed the view that women who are born as women still require a recognition of that fact, particularly with regards to safe spaces. So whether we're looking at hostels for victims of domestic abuse, or we're looking at prisons, or we're looking at other things, okay, there is a need for a female safe space. That is something which is anathema to many trans rights advocates, okay, and that is a dividing line, and it's an interesting dividing line, I think, here, because of course both actually are quite a liberal view, yeah, and for many purposes are actually on the same page, but on this there's becoming a real dividing line, and that has now fallen over into the tribunal. In this case, the Forstater and CGD Europe case, which went to the Employment Appeal Tribunal last year. And it really starts to hone down some of the issues that we're going to see, as I said, not just with regards to transgender rights, but it's going to be a specific issue, but also with regards to other things. What are those issues? Well, Forstater is an academic, and again, she approaches this from a liberal and a feminist perspective. But her view, which is expressed via Twitter, she's expressed in other debates, is that biological sex is real, important, immutable, and not to be conflated with gender identity. I.e., she believes that if you are born female, then you are female. If you are born male, then you are male. And that needs to be recognised, again, for safe spaces in particular, and for other purposes as well. She was, like I said, she pushed these views. She was very rational and very sensible in the way she pushed them. in Twitter and on various other debating forums. But the effect was that a number of students who were in the study site at which she was working complained, and her contract was not renewed. She asserted that she had been discriminated against because of her belief, the belief that I've put up there, although it's much more nuanced and complex than those words can sum up, and that that discrimination was unlawful. The question then, and this was a question which the Employment Tribunal had to grapple with, and then the Employment Appeal Tribunal needed to grapple with, is this a belief worthy of protection under the Equality Act as a philosophical belief? And the Employment Tribunal looked at this in 2 days, and they were very conscious of these competing issues. First of all, that conflating gender identity with biological sex undermines a woman's right to safe spaces, as I said. Secondly, however, and crucially in this case, given the way in which the Employment Tribunal decided on this, misgendering, i.e. being referred to by your non-preferred pronoun, so he rather than she, is a form of harassment. And it's accepted that that is a form of harassment that many transgender people suffer. So how did it resolve this? Well, it went back to the law and it asked itself, well, if we have a philosophical belief, is it worthy of protection? And to ask ourselves, is it worthy of protection, we have to apply the Granger test. There are 5 steps to the Granger test, which are set out there. They said, yes, it's worthy of protection for 1, 2, 3, and 4, but crucially, not 5. Forstadter's belief is not a belief worthy of respect in a democratic society. It is incompatible with human dignity, and it is in conflict with the fundamental rights of others, and in particular the fundamental rights of trans people not to be harassed at work. And this is the issue which the Employment Appeal Tribunal then needed to grapple with. What did the Employment Appeal Tribunal say? Well, they said the Employment Tribunal had got it wrong, that Forstater did have a philosophical belief worthy of protection. And in doing so, it's a very, very good judgment, very well considered judgment, balancing a number of very difficult issues. But here's what they said: the claimant's belief might well be considered offensive and abhorrent to some, but the accepted evidence before the tribunal was that she believed that it was not incompatible to recognise that human beings cannot change sex whilst also protecting the human rights of people who identify as transgender. And her evidence was very clear that she had respect for transgender people, but within her own boundaries. She believes that they deserve protection from discrimination. That is not, on any view, a statement of a belief that seeks to destroy the rights of trans persons. It is a belief that might, in some circumstances, cause offence to trans persons, but the potential for offence cannot be a reason to exclude a belief from protection altogether. I.e., there's actually a very high threshold for that final point about belief being, or we could say a very low threshold, I suppose, about a belief being worthy of respect in a democratic society. Effectively, if it is not akin to something which is abhorrent to society, then it is going to be worthy of belief, provided 1 to 4 are also set. So this has implications of itself in the workplace with gender identity, which, as I said, is becoming an increasing issue. There's another case, it's an Employment Tribunal case, I haven't talked about it, which looks at this in the context of a doctor whose religious belief meant that he believed he needed to refer to someone, use a pronoun which was compatible with their birth sex. So, if even though a trans person might identify as a woman, he would feel the need to refer to them as he rather than she. Now, that was a manifestation of the belief. And that was, whilst the belief itself might be worthy of protection still, the manifestation of it, the fact that he acted upon it by referring to trans people, misidentifying trans people, was the issue. That manifestation was not protected, and therefore it was okay. It was lawful to dismiss. But this is the kind of thing that we are going to see increasingly. And if we look at the kind of cases we've seen around belief, we've seen cases on veganism, we've seen cases on environmental activism, we've seen cases on sexual orientation. What we haven't yet seen is cases on COVID. and in particular vaccinations, and those people who do have a principled stand against vaccination. Just going back to what we were talking about earlier, and I hate to throw another spanner into the machinery, or whatever you do with a fly and ointment. We are going to have to be careful about separating out a belief that vaccines are bad from a manifestation of that belief, which is I am not being vaccinated, and that has an effect on my job. So we've got to be very, very careful around this issue. I've talked about that case at length, not because it might be something which you think, right, immediately this is relevant in the workplace, but it is undoubtedly the start of an issue that we have seen in other areas, particularly sexual orientation, where there is a real sense that beliefs start to clash. And unfortunately, HR professionals, employment lawyers are going to have a role to play in sorting that out. So I'm going to stop there and hand back.
Okay.
Yeah. Thank you.
Okay. So last topic for this morning is menopause at work. So there was a 2017, so that was 5 years ago then, Equalities of this report.
Not sure that long,
and it looked at the increased rates of employment among women aged 50 and above, and essentially said that what this means is that working women more than ever before are going to experience menopause transition during their working lives. We know that the symptoms of menopause are both physical, or can be both physical and affect mental health as well. They vary in severity, but they can have a significant impact on a woman's ability to perform as usual in the workplace. There is an ACAS guide called Menopause at Work. I put the link on the slide there to the ACAS guide, and that was published in October 2019. And it's essentially guidance for employers and workers about how best to handle menopause-related issues in the workplace. And it talks about, it recommends employers have a specific menopause policy, setting out how staff can raise issues relating to menopause and how they'll be handled when they're raised. It recommends reviewing health and safety policies, risk assessments to ensure that they cover the menopause, and also has some guidance with regards to managing sickness absence and job performance. In July last year, the Women and Equalities Committee announced an inquiry into workplace issues surrounding menopause. It examined existing discrimination legislation and workplace practices to consider whether enough is being done to prevent women from leaving their job as a result of menopausal symptoms or from suffering other adverse consequences. And it includes considering whether legislation is required to mandate a workplace menopause policy. The outcome of the inquiry is awaited, although I understand it closed in September, so it should be due soon, you would hope. There was a second reading of the Menopause Support and Services Bill in the government towards the end of last year, end of October, and they outlined some actions that they intend to take to address these issues. But some of the points they made were that it's important that employers create a supportive environment. Made the point that flexible working options can assist those in menopause. And it said that this is going to be a women's health strategy priority in England. They've also commissioned an independent report, and the outcome of this report recommended that the government enact Section 14 of the Equalities Act. I had to look this up. So Section 14 is essentially where the Equalities Act talks about dual discrimination, where you can bring a discrimination claim on the basis of two protected characteristics, not just one. And this would be, if brought into force, would be highly relevant for women going through the menopause and who feel they suffer discrimination, because, of course, the most likely dual discrimination claims they could bring would be, for example, age and sex, or perhaps sex and disability, or disability and age.
All three, or just have to be dual?
Well, it says dual, but we could go triple. So essentially, what I'm saying is that this is something that is being talked about increasingly so, and it's something that we need to be looking at. In terms of menopause policies, well, what would their purpose be? Well, as I've said, to raise awareness of the menopause and the impact how it can affect people and the support available to staff affected by it. It can help show that the organisation is open and perhaps trained to talk and listen sensitively to the effects of menopause. It could also include some information on gender identity and gender reassignment discrimination, because it kind of inform people that actually menopause can also impact trans persons and non-binary people who don't identify as female as well. So it's all about raising awareness, information, making sure managers are trained if these issues come to fore, and how to deal with these matters sensitively and confidentially. Potential areas of liability. And I put a few cases on there, and actually I didn't realise there was actually so much case law actually around this already, but you'll see actually just from the dates that most of these are very recent, but they are actually, I think there's one EAT case, but the rest are tribunal cases, but nevertheless I think they're useful to briefly talk about. So the kind of most obvious initial area of liability is where you're potentially managing sickness absence for a lady who has a high level of sickness absence due to menopausal symptoms, and also perhaps whose job performance has dropped, and how you manage this. The ACAS guide recommends menopause absences should be recorded separately from other absences, so that's something to consider. And also recommends that take into consideration any performance issues that might be because of menopause symptoms, and the tribunal case I'm going to talk about in a minute highlights the importance of that. And also recommends that you consider reasonable adjustments. Now, of course, if it is considered that the menopausal symptoms for a particular individual does constitute a disability, then of course the duty to make reasonable adjustment does apply. What I didn't say before, but I think you know, is that menopause, of course, itself is not a protected characteristic under the Equality Act. But tribunal case law does demonstrate how an employer's treatment of staff undergoing menopause can potentially give rise to discrimination. So there's obviously age, because menopause usually relates to the age of the employee. So less favourable treatment of staff undergoing menopause may give rise to an age discrimination claim. But the case law really so far has been in relation to disability and sex discrimination. So with regards to looking at disability, as I've said, symptoms can vary in severity. Sorry, I keep coughing this morning, and I'll talk about COVID this morning. It's not good, is it? Man jumped out the window. But symptoms can have a significant impact on a person's day-to-day activities and their ability to perform as usual in a workplace, which may, of course, mean that it amounts to a disability under the Equality Act. And I've said, if so, there's a duty to make reasonable adjustments. So the first case, and I don't know how to pronounce the surname, but which was brought against, we'll call Mrs. D against Talent Technology Services. The tribunal considered whether her menopause symptoms were substantial enough to amount to a disability. So the claimant experienced hot flushes 7 to 8 times a day, regularly accompanied by palpitations and anxiety. Frequency of flushes increased when she was under stress or pressure. She also began experiencing night sweats, waking frequently in the night, and so then began to experience fatigue, anxiety, and memory and concentration difficulties. She gave evidence that it impacted her day-to-day activities, such as household chores, walking, reading, writing, using a computer, and of course sleeping, as mentioned. The employer argued that she merely suffered from typical menopausal symptoms, and therefore the impact was not substantial. The tribunal didn't like that. The tribunal said that actually the impact of her symptoms on her day-to-day activities were more than minor, and therefore they did amount to a disability. And they said that they could not see any reason in principle why typical menopause symptoms could not amount to a disability. So I think that's important just to explain how potentially, menopausal symptoms can amount to a disability. The second case, Gallagher against Abellio, this is an EAT case. And this was where the employer actually conceded that the claimant was disabled due to her menopausal symptoms. But actually, this is a case where the EAT upheld a tribunal's decision that the claimant's treatment was actually unrelated to the disability, which included dismissal during her annual appraisal. And essentially, what they found here is that there were difficulties between herself and her manager that started before the menopausal symptoms arose, and the reason for dismissal was actually inachievable breakdown in trust and confidence between two senior managers at a critical time for the business. So it's just, I've just put it on there just to kind of give some comfort perhaps, but the tribunals will look actually as to what the reason for dismissal is. The last case, how would you say, McMahon? I'm rubbish with, yeah. Just give me Smith or Jones any day and I'm fine. She was dismissed for timekeeping problems, extended breaks and continued absences. She argued that the reasons for these absences and timekeeping issues were due to her menopause symptoms, and our tribunal again held that the symptoms amounted to a disability. The tribunal also found that her dismissal was because of something arising from her disability. So the dismissal was because of the symptoms of the menopause, which then caused the timekeeping issues and the absence. However, they went on to find that actually her dismissal was a proportionate means of achieving a legitimate aim, because of course an employer can actually justify this particular claim. So they found that her absence levels were very disruptive in the context of the role she was performing for a small business that needed someone who was specialised and reliable. This is obviously a very fact-specific case, and I haven't gone into all the facts, but it just, I think, is just a case that I put on there because it's relevant, and it basically says that, you know, if you are looking to dismiss or discipline somebody because of absences, timekeeping that's related to menopausal symptoms, then we do have to be careful, particularly with discrimination arising from disability, and be comfortable that we can justify and are being reasonable in the decision that we take. Sex discrimination, so Merchant and BT. This employee was dismissed following a final written warning for her poor performance. Now, she had previously given her manager a letter from the doctor that said that she was going through her menopause and this can affect her levels of concentration. But actually, in dismissing her, the manager chose not to make any further inquiries as to her health conditions, which was actually in breach of BT's performance policies. And the tribunal upheld her claims of direct discrimination and unfair dismissal. And the tribunal held that the manager would, I quote, never have adopted this bizarre and irrational approach with other non-female related conditions. Which I thought was quite an interesting firm judgment from the tribunal. And finally, we have the case which was a horrible case actually. This particular employee suffered harassment in the workplace. So her male manager would demean and humiliate her in front of younger colleagues and called her a dinosaur. And on one occasion, criticised her for failing to staple together two pieces of paper and said it's because you're going through the menopause. Not a nice case. He also made numerous other comments about her being menopausal and about her performance. He also refused to adjust the temperature in the shop to make her more comfortable because she was suffering from flushes. It wasn't a nice case, but the tribunal upheld claims for both sex and age harassment. And of course, I just think it is worth bringing these cases to your attention because they are coming through more and more. It is clearly a very important issue, and I would recommend looking at implementing a menopause policy.
We have a couple of questions on that.
Oh, we do. Oh, see, now I'm not sitting right in front of my laptop.
Shall I go forward and read them out to you?
It's all right, I can do it. I'm just going to squint really and I can't see the screen. So, any updates as to when the proposed change to tipping will be introduced? Although I saw an email on that this morning. I didn't read it, that's helpful. And to confirm, we run all cash and card tips through payroll. As I understand it, deductions can still be made in respect of tax and NI.
I don't know the answer to that. I think what we'll do, because it's an important but niche issue, so we'll do a little update bulletin on that one and send it around. So you've got chapter and verse up. Vanessa's looking at her emails, seeing if.
As soon as parliamentary time allows.
Ah, right. Okay, so as soon as they stop talking about whether Boris was at a party or not.
Yeah, it does. Legislation will require employers to pass on all tips, gratuities and service charges to workers without any deductions. Proposal also includes a new right for workers to make a request for information relating to the employer's tipping record to enable them to bring forward a credible claim to an employment tribunal. But yes, as soon as parliamentary time allows is the answer to the first question. The second part, I think we will have to.
I think, yeah, you're right to put them through. You're right to put them through payroll. I think it's just the other comment I just made there is that it is still on the horizon. Again, I assume when parliamentary time allows to have one enforcement agency for all employee-related matters, and I think this is one of the ones which has prompted that move. Yeah. Because you're obviously doing the right thing with tips, but there's an awful lot of employers out there who are not. But the amounts tend to be very small, and employees tend not to claim. So it's probably an area which, as and when parliamentary time allows, we'll see some movement in.
Yeah. Okay. Menopause has recently been raised in my workplace as an issue, and I proposed seeking occupational health advice. Is this sufficient?
I think if it's presumably if we're talking about an individual case, then occupational health is the place to go. Yeah. I suppose if it's a general thing, it makes sense to go to an expert to look at some to look at how to take it into account in the workplace, and occupational health seems a really good call on that as well. So look at the ACAS guide, seek some advice, but certainly. Having picked up the theme from the cases Vanessa just read out, which is that there seems to be quite a lot of dismissal of the symptoms, then actually going off to occupational health and is a sign that you're treating those symptoms seriously, which is well ahead of many employers.
Yeah. Somebody's commented that we recently introduced a menopause policy, but are now amending it to include andropause, male menopause, for fear of not being inclusive for male colleagues. I haven't come across
andropause. That's an interesting concept.
Yeah.
I think this is. It sounds like it's worth doing, because you're actually getting to the real issue, which is that this is about symptoms and effects rather than simply about sex, race, disability, or anything else. So from that perspective, it sounds sensible. I suppose the comment I would make is, well, where do you stop? And if it were down to me, then the next move on from andropause is man flu. It's an important condition. So
who brought you in on this webinar, hey? So final, we are past midday, but we're going to continue whilst there are still some questions. But if anybody does need to go, thank you very much for listening to us. And if you could just quickly complete the kind of 2-click survey at the end when you log out, that would be fab. Thank you very much. So I think the question we've got is, as an employer, you might respect the fact that menopause is a real issue, but if it's affecting their concentration and therefore the ability to do their job effectively, where does that leave you and them? Well, it kind of goes back to the case that I mentioned, doesn't it, really, in that you would need to carry out a performance process, but you would have to take into consideration the reasons behind the poor performance. If it is severely affecting poor performance, like any disability, this doesn't prohibit you from taking the decision to terminate ultimately, but you obviously run the risk of potential claim, particularly disability arising from discrimination. But then you do have the opportunity to defend that claim on the basis that the decision you took was justified.
Yeah, I think this is what the law's about, isn't it? It's focusing on the effects of a condition, whether from a age-related, disability-related, sex-related position, rather than that characteristic itself. And what you do by that is you move potential liability from direct discrimination to indirect discrimination.
Yeah.
And as soon as you're in the territory of indirect discrimination,
Yeah.
it is potentially lawful discrimination, provided that you've got your proportionate means of achieving a legitimate aim.
And you need to look at adjustments.
And obviously adjustments comes into it, but that's sort of where the law wants to get you, which is focusing on an effect rather than a condition itself. So so you're moving in the right direction.
Yeah, great. I've just got some thank yous, which is lovely.
Well, thank you all for listening.
Yes, absolutely. Yes, and we will aim to get one up next
March.
Yeah.
Next March or next month?
Yeah, having a year off, having sabbatical from everyone else. No, in March, next month. Sorry.
Yeah, and we always like any suggestions for what we
Yes.
should be talking about.
We do, yes. So if you're able to give any suggestions when you log off and give the feedback, that would be great as well. But any other questions, then do email them through. And thank you everybody for attending. Take care.
Bye.
Bye.